This isn't just another courtroom case. A mother accused of harming her own children, 10 of them. The judge says it's one of the worst cases in 30 years.
Due to injury to a child, a first-degree felony. I've received the pre-sentence report, as well as I've visited with the attorneys. And for the record, we have also Ms. Randy King here, who is the assistant district attorney that handled the termination and CPS kind of portion of this case with regard to the children. I've received. Has everyone had an opportunity to review the pre-sentence report?
Yes, Your Honor.
Are there any additions or corrections to that report?
No additions or corrections.
Ms. Smolfino?
Judge, I would just ask the court take judicial knowledge of the conversation we have had with the court and the understanding that this has been discussed at length upstairs. Ms. King has also provided me a tremendous amount of guidance, which I thank her and appreciate everything she's done with her wealth of knowledge and experience in guiding me through this case. I know the facts themselves are extremely egregious. It's difficult for all of us to look at. I would recommend Ms. Schultz is getting this opportunity because she has availed herself of certain things and tried to make progress. The children, her rights have been terminated, which she voluntarily gave them up, and they have been relocated out of state to a stable environment to where they will not have to testify against their mother, which was something that we took into a great deal of consideration. I would ask the court consider special needs safety in lieu of ISF cognitive. I think it is a more lengthy and a more appropriate term in custody as either an upfront type of sanction, but more so to give her the tools to be successful on this probation, because as the court is aware, and I'm sure Mr. Samuel has advised Ms. Schultz, and I do not mean this statement to seem punitive, but if Ms. Schultz is back before you on a violation of this probation because of this opportunity she's been given, the amount of time that the state will be asking for will be overwhelming.
Thank you, Ms. Smolfino. Anything, Mr. Samuel?
Yes, Your Honor. I understand the position of the state. However, I have to look at things from the position of the individual. The pre-sentence investigation report shows that she has no prior criminal history. It shows that she has no drug problem. There is a question about the alcohol. However, we believe that that can be done without the need of the inpatient treatment of the ISF. We believe that she's finally working. That is one of the most important things that she has to deal with in what she's gone through. She's experienced the trauma of relationships, and I think all of that is stated in the pre-sentence investigation report. But what you do not hear is the experience with the other partners of the children. She has carried this burden. She has tried to do the best that she could at the time. She's educated, she has a degree, but she has not been able to find employment. She's finally working, and we just ask that this be held in advance for at least 90 days. That will show if there's an alcohol problem. That will show if there are other problems that she's experienced. She has been to a mental health specialist for counseling, and she will get with them again. And we believe that if that is a part of the order for mental health compliance and conditions, she can do that. But let her prove to the court that this is not just her as it is today. This is a result of everything that she's experienced in her life at this point. I just pray that the court will have mercy on her and give her that opportunity.
Well, Ms. Schultz, you're getting mercy today. You're getting mercy from these ladies as well as myself, if I go along with this agreement. Mr. Samuel has worked very hard and is very passionate about helping you, and I appreciate that. My position on this is based on a couple of things. One, the horrendous nature of this offense and what you put all of your children through, all 10 of them, is beyond anything that I have seen in 30 years of practicing law. 30. And so you're not walking out of here today. My initial thought was some upfront time, but if I'm going to stick you in jail, then I might as well put you somewhere where you're getting some help that you need, so that when you are released, you hopefully will be able to be a productive part of our society. But whatever trauma you've been through is incomparable to the trauma that you've put your children through. So at this time, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. I'm going to follow this agreement only because of the work that Ms. Malfino and Ms. King and your attorney have done, and the agreements that they've reached, and I understand why. Part of that is so that your children don't have to be re-traumatized and come back here for a trial and testify against you. I don't want to re-traumatize your children, and that's the only reason I'm really going along with this. So I will defer all proceedings, place you on probation for 10 years. You will be ordered to pay the $1,000 fine and follow all of the rules and conditions of probation. One of those is going to be that you enter and successfully complete the special needs safety program. You will be on the mental health caseload when you're released, and you'll have aftercare through Spindletop. That is now part of your probation. So if you don't follow through with any mental health services that are recommended through Spindletop or probation, that's going to be a violation of your probation. You will also be ordered to remain in Jefferson County, Texas. You cannot leave Jefferson County without permission. You cannot go anywhere near or see your children. You've terminated that relationship. I know they're with family, and so there's no Christmases where you show up or they bring the children down or anything like that. That's done. That's over. If you want to leave Jefferson County, it has to be with my permission, and I will have to know where you're going and to what extent and things like that. If you do everything you're supposed to do on this probation, I cannot stress enough what kind of opportunity this is that you're being given. If you, however, violate any condition of probation, if you're back here in court, obviously this isn't a case that I will ever forget. And Ms. Malfino will also, like she said, if you violate probation and come back in here, depending on the case, what you violated and how you violated, you could go to prison for anywhere between 5 years and up to the rest of your life in prison. Do you understand? Yes. I'm handing you the trial court certification that shows this was an agreement and I followed it. So you've waived your right to appeal. So you can go, that's for her. You can go back with the bailiff. Thank you, Ms. King. Thank you, Ms. Malfino, Mr. Seaman. Did I already do any of the sentencing, or did I just let you guys kind of know that I was leaning towards probation and that we needed to have?
I know it's indicated on January 26th of this year, we appeared, we discussed the PSI. There was a disagreement as to the restitution. The court says that it was inclined to place the defendant on a concurrent probation, given the length of time between office date and the indictment. Then fast forward to February the 9th of 26, the case was simply just reset for restitution hearing. So it looks like you didn't do anything.
And haven't actually sentenced yet.
I don't believe you did, Judge.
Okay. And have you, all right, ma'am, you're Janisha Leonard. And Ms. Leonard's here in 3 cases. One is cause number 25 DCCR 0297. That is the new theft of property case, a state jail felony. She entered plea of guilty to. And then we have 2 MTRPs, one in cause number 19-33340, theft of property, and 20-36095, a theft of service. And in each of those cases, is she on a deferred in both of those? Or is it straight? I'm trying to, sorry, I should have. Is it a deferred probation?
Let's see, Judge.
No, they're straight probation, Judge.
Okay.
Yes.
So they were deferred, and then we were here, and then revoked that deferred and reassessed and did the 2/5 at some point. Is that correct?
The last information I have in my files is she was on a straight post-conviction probation. I don't know if she initially was on deferred or not.
Yeah.
I don't
Okay.
know.
All right. Yeah. Okay. So, the biggest issue that one of the bigger issues that I had when we were here for sentencing, based just on paper and the appearance of this, I don't disagree with Mr. Coleman's assessment of the case, with the criminal history, of Miss Leonard with these types of offenses, and, which the criminal history is these three cases. There aren't any other cases. And the new offense date was August of 23. And it's kind of just unknown. It sounds like why that case was delayed in prosecution. Doesn't look like anybody knows. And so the time frame between that and now, and the lack of any other cases while Miss Leonard has been out and on probation during that time and doing well, it looks like otherwise on probation, is what leads me to potentially move forward with continuing the probation potentially on the others and giving her a probation on this one. So there was no agreement on any of these, but it looks like there was an issue with regard to the amount of restitution. So let's go forward with that. Have you guys come to any type of agreement on the restitution?
We are very
We're very far apart, Judge, and I guess one of the issues that we have is I believe Mr. Coleman's got some exhibits that are going to go back to 2022. I would object to looking at anything outside the range in the indictment. The indictment goes from August 23, and we'll get to the exact dates.
Let me get it pulled up as well.
August 24th, 23 to September 4th, 23.
Okay,
I would ask that we remain in that range.
I would think legally that would be probably what I would need to do.
Judge, it's a continuing course of conduct. The theft is, I'll be honest, Mr. Ross just brought that to my attention this morning. I haven't had a chance to research it, but he certainly has had all of the restitution information showing that it's going back to 2022 in that discussion. So it's not an unfair surprise for him to know that we're looking for restitution going back.
Well, but I think the allegations, and obviously I understand the honor about as well as any of you guys, but those are some pretty specific. I mean, that's a very short time frame that is alleged in the indictment. We're talking what, 4 days?
Well,
5 days?
yes.
Well, yeah.
From August 24th, 2023 to September 4th.
I'm sorry, I'm looking at an old indictment. I'm sorry, hold on. I was looking at another
About
case.
10 days, maybe.
Hold on. So in the new cause number. So yeah, this one is August 24th of 2023 through September 4th of 2023. So less than a couple of weeks, a couple of weeks or so is the allegation. And I don't want to have to keep coming back here. But I think to go back, if it was a few weeks off or a month or two off, but if we're talking years of requesting that, then I think that's something that indictment needs to allege. And so we can go forward with that time frame today. I think legally that's where we need to be. She's already pled to it, so I think it's kind of late to amend the indictment. So with regard to the time frame of August 24th through September 4th of 2023, what is the amount between that time frame? Do you guys have that? Or need some time to look at it again to make? And I mean, and the unfortunate, I want to make sure you guys know how I am. If someone has had something stolen, I want them made whole as much as possible. I just don't think we can go back
Sure, Judge.
that far legally. So I make sure that the victim understands that as well, that we've got kind of a limited time frame here that we need to move forward on if I'm going to order restitution and probation. Y'all need a minute to do some math?
Just a
on-
quick minute, Judge.
Yeah, y'all go ahead. Y'all have a seat based on, I guess, that. See if there's something you guys agree to as far as that time.
Just based on an on or about date, and they understand that the court's willing to kind of go back a number of weeks. I've got receipts to go back as far as, I believe, August the 9th of 2023. I don't know that that would necessarily be, I think that would be enveloped in the on or about. I mean,
I wouldn't disagree with that.
so
So August 9th, 2023. And then what was the last?
the last
Is that the September 4th date?
the last one is, I don't want to misquote. Let's see here. September the 4th is the last day.
All right. So you guys figure out what between August 9th and September 4th of 2023 number is and see if there's an agreement on that number. So Mr. Ainsworth, you tested positive for marijuana. When's the last time you smoked marijuana?
The week of New Year's.
I don't believe that. When's the last time you smoked marijuana?
It was the week of New Year's, but like 30 period.
So you smoked a lot?
More than so I wouldn't say I smoked. I had asthma. I can't really smoke. I did have just 3 days in a row.
You did what, 3 days in a row?
Edibles. Yeah, I'll take accountability for that.
Well, I appreciate that, but you're here on a felony. And you're waiting on sentencing on a felony where you're getting this great deal with the deferred probation and you make such a dumb decision. How old are you?
So,
All right. You have no history. All right, here's what I'm going to do, Mr. Ainsworth. I'm going to find that you previously entered your plea of guilty freely and voluntarily. I'm going to, find sufficient evidence to find you guilty. I'm going to follow the agreement that you made with the district attorney. I'm going to defer all proceedings and place you on probation for 4 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. One of those is going to be, well, a couple of things. One, I want a substance abuse evaluation done just to see if there's any underlying issue that needs to be taken care of. And if so, whatever treatment they recommend, that's what you have to do. In addition, I am going to order that you wear a drug patch for some amount of time between now and whenever probation feels like it's been long enough. You need to have that drug patch on within 24 hours. If it tests positive, which I understand that it may this first time because there's obviously still something in your system, but those drug patches also give a quantity, not just a positive or a negative. And so that quantity should be going down. Do you understand? If it's staying the same, if it's going up, then I have no choice but to believe that you are using marijuana again. You're going to end up, what I'm going to do is if there's a positive drug patch, probably after the first one or so, I'm going to let probation work on this, then I'm ordering right now that you enter and successfully complete the substance abuse track of the ISF program, but I'm going to hold that in abeyance. So let me explain what that means. ISF is a 90-day in custody treatment program. I'm not going to make you go today, but if you test positive for marijuana, again, probation doesn't have to come to me. All they have to do is send a paper over. I sign it. There's a warrant issued for your arrest. You go into custody and then you go to that treatment program. You understand? So this opportunity is an excellent opportunity that you're being given today because you don't have a felony conviction on your record. You'll never be a convicted felon if you successfully complete this probation. At the end, the case is actually dismissed. If you violate, though, you could be brought back into court, found guilty, so you become a convicted felon, which will ruin your life in many ways. And you could go to prison for between 2 years and up to 10 years. Do you understand? So if you're, whatever it is, edibles, smoking, whatever, even if you think it's not the illegal kind or whatever, if you test positive, you don't need to use anything at all that could potentially test positive for THC. Do you understand? If you're having issues with that and there's some type of issue, then you need to talk to probation. Because if you ask for help up front, they might get you some outpatient treatment instead of this ISF. But if you don't and you test positive, you're gone. Okay. All right. I'm handing you the trial court. Sorry, they're going to hand you the trial court certification that will show that this is an agreement that I followed. And so you waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up when they're ready to go over your paperwork. Good luck to you, sir. Just anywhere in the court. She's going to call you up to her desk. So just listen for your name.
Yeah.
Jeffrey's not back yet. Okay, Mr. Kevin Lane on Ahmad LeBlanc. Oh, wait, I don't have that back yet. Hold on a second. I don't have the drug test back on Mr. LeBlanc.
Yeah.
All right, Miss August, come back up, ma'am. All right, Miss August, you tested negative, which is obviously a good thing. How old are you? I'm sorry?
I'm 22.
Are you, did you say you are or you are not working?
I just really stopped working.
I can't understand you.
I just really stopped working like 2 weeks ago.
And why was that?
Because I was sick and I slept in my work like 30 minutes trying to get better and they said I was sick at time. But I'm looking for a job now.
I'm going to find that you qualify for a court-appointed lawyer. I want to get something working on your case since you're on probation and we're having all of these issues that we've been having with regard to alcohol and things like that. I'm going to have you step in front of the clerk. She'll let you know who that's going to be. I also want to warn you today, if you test positive for anything, including alcohol, again, we won't even have a hearing. There will be a warrant that goes out for your arrest. You will be in custody, and you obviously you already are, and you definitely will at that point be looking at your probation being revoked. Do you understand?
Yes.
So there's no slipping up. There's no taking a sip of a twisted tea or anything else that you're saying you're doing. If you do that, you're in jail and potentially going to prison. It's that important. Okay, step in front of the clerk. Mr. Rennick on Badreddine Al-Haroni?
Yes, Your Honor.
I highly doubt that I said that correctly, but I
Last
tried.
name was good.
The last name was?
The last name was good.
Good morning, sir. How do you say your first name?
Badreddine.
Okay. Mr. Al-Haroni?
That's why I said the last name.
Yeah, so Mr. Al-Haroni is charged with possession of child pornography in cause number 25 DCCR 1378. And what is the announcement?
The prosecutor and I have met about the case. We spoke last week and we spoke again this morning. I don't know if you want to speak to, there's some issues with the indictment. But the other are, since she has taken over the case, we're kind of discussing a resolution.
So I see that there was a motion to quash the indictment that was filed some time ago, back in December. What I can do is just reset it, Ms. French, since you're just getting on the case, give you some time to look at that indictment. If something needs to be amended, you can take care of that. If you think it's fine, then we'll have the hearing on the motion to quash at the next court date. And, or if you guys come up with some agreement, we can take care of that. But I'll just do a normal reset so you guys can look more into it.
And she jumped into it pretty fast. We've had some really good.
Yeah,
pretty good
no, I have no doubt she has. She's jumped into them. So we'll do a normal reset. Stay in touch with Mr. Rennick so that once he gets any information, offers, things like that from the assistant district attorney, then you can visit with him and we'll see if we can get a resolution.
Thank you,
You're free to go. Thank you.
Thank you, Your Honor.
Morning, gentlemen.
Good morning. Morning. All right, so are you diving, Kalina?
Yes, ma'am.
This is 24 DCCR 2432. Mr. Kalina is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
Judge, I think we're on the goal line to a resolution. The court would allow a last reset.
Any issue?
Judge, Mr. Cat was on this for quite some time.
Yeah, I see that
Mr. Kelly has been on a shorter period of time. We're not quite there yet. We've kind of countered a couple different things, made a few phone calls, but we're doing our best.
Thank you. I'll just do a normal reset. This, I know you haven't been on it very long, but this will be the last reset just because the case is getting long in the nature of the offense. And so make sure, Mr. Kalina, that you stay with get in touch and visit with Mr. Kelly before that next court date. Once he gets any final offers from the state, you guys can go over that and we'll get an actual announcement at that next court date. Okay?
Thank you, Judge.
Thank you.
Great. So you're Raquel Glover. And Mr. Glover's case is set for trial to begin with jury selection next Monday and cause number 24 DCCR 0232. And what is the announcement?
Your Honor, the state had tendered a new offer today of 10 over 10. Mr. Glover's informed me that he's refusing that. We're still requesting a trial.
Great. Any issues?
Thanks for the trial, Judge. We're ready.
All right. So Mr. Glover, I'm going to number the case for trial. Your case is very old. It's likely to be somewhere near the top of the list. After today, I will not accept this agreement. So you have every right, obviously, to have a jury determine if you're guilty or not. If they find you guilty, what your punishment is. But after today, we're not going to come back and do a probation tomorrow or Monday afternoon at the last minute. Today's the day for that. Okay. All right. Stay in touch with Mr. Kimler and your bondsman, and we'll see you back next Monday at 1:00. Okay. Good morning.
Morning.
Good morning, sir. Brian, is it Barrier? And Mr. Barrier was previously in court, entered a plea of guilty to the third-degree felony offense of placing a serial number with intent to change the identity. I've received that pre-sentence report and reviewed it. Have you all had an opportunity to review that?
Yes, Your Honor.
Yes, Your Honor, we have.
Any additions or corrections?
No, Your Honor.
Not from state, Judge.
All right, sir, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made and find you guilty of placing a serial number with intent to change identity. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections, but that will be suspended. You'll be placed on probation for 3 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over, and you'll be able to serve that 3-year sentence while you're out on probation. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you could be facing that 3-year sentence that you've already agreed to. Do you understand? I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Smith. All right, good luck to you, sir. If you'll just have a seat here in the courtroom, probation is going to call you up to her desk when she's ready to go over your paperwork. All right, good luck. And then you've got Cedric Franklin sentencing, Mr. Smith.
Yes, Your Honor.
Good morning, sir. Are you Cedric Franklin?
Good morning, that's fine.
And Mr. Franklin, before I go forward with your sentencing, there was a couple of concerns I had with regard to maybe some previous drug use. I'm going to have you tested this morning before we go forward with sentencing. Have a seat in the jury box and we'll get that done. And then we'll go forward with sentencing. Fabian Hall sentencing, Mr. Smith, obviously about the decision making. So what I'm going to do, Mr. Hall, I'm going to follow the agreement that you're making, but I'm going to add, and I had already gone through all of that, correct?
Yes.
So in addition to the 7 years deferred probation, the $1,500 fine, the parenting class following CPS orders and all of that, I'm going to order that you enter and successfully complete the substance abuse track of the ISF program. That means you will go into custody today. And you will complete the ISF program. And when you get out, you will do JCDI as your aftercare, which is an outpatient treatment program. Obviously, if you are doing and around people that are smoking marijuana and you've got 4 kids living with, where were your kids yesterday at the barbecue? Were they with y'all?
They was
They weren't. So instead of being the good dad that you're saying you are, you're out at a barbecue without your family.
No, the family was there not around me though.
Okay, so your kids were there, but they weren't around the people smoking marijuana. Okay. That sounds ridiculous, doesn't it?
No, I'm being honest.
Okay. Well, you're going to enter again. We're going to hopefully get some better decision making done. If not, you're going to end up back in here if you violate any condition of probation. If you test positive for marijuana, if you violate any of these other rules, you'll be back here in court and you'll be looking at a sentence between 2 years and up to 10 years. I'm handing you the trial flip certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You're going to go with the bailiff. I think have a seat in the jury box so probation can go over that paperwork. All right, go back with the bailiff, sir. Jeez, how many is that? They're going to have a lot of shackles back there. Okay, good. Mr. Galmore working on styles. I'm waiting on Mr. Jeffries. We might want to send a message, make sure Mr. Jeffries remembers he needs to come back over for Mr. Gomez.
Let's see these next ones.
Thank you. Ms. Malfino, this is Christian Ainsworth sentencing. Mr. Ainsworth, I have a notation here. I'm going to have you drug tested this morning here in court before we move forward. If you'll please have a seat in the jury box, we'll get that done and let you take care of your sentencing. Have a seat in the jury box.
Miss King is here, Judge. I just didn't see what I'm sorry.
Yeah, I'm going to hold that for just a second. I want to visit with you guys.
Okay.
Mr. Rojas, you've got Tashawn Bass, 2 cases. Good morning. Are you Tashawn Bass? And Mr. Bass is charged in each of his cases with aggravated sexual assault of a child in cause numbers 25 CCR 0832 and 0833. And Mr. Rojas, what is the announcement?
Speaking with Ms. French last week, after exchanging emails, I think she needs more time to talk with the victims. It's a new case to her.
Sure,
She didn't have had time to look at everything yet.
Okay. Anything else that I need to know of, Ms. French? Sure.
No, Your Honor, Mr. Rojas expressed that correctly. I would like to talk with the family and the victim before an offer is made.
All right, so I'll just do a normal reset to give Ms. French some time to get that taken care of. She'll get that information and an offer to Mr. Rojas before the next court date. Make sure you stay in touch with Mr. Rojas so that once he has that information, you can go over it with him and we'll see if we can get an announcement at the next court date. All right, free to go.
Thank you, Your Honor.
Thank you. And then it's Mr. Bruce Smith.
There.
Good morning, sir. Are you Christopher Stiles? And Mr. Gilmore, will your client waive the formal reading of the indictment?
You will, Your Honor.
I'll take it.
Sorry.
Mr. Stiles, in cause number 25, BCCR 0594, you're charged with the state jail felony offense of abandoning or endangering a child from April 28th of 2025. And how did you plead to that charge?
No contest.
Under these circumstances, and Mr. Galmore could probably elaborate more, the state's not opposed to a no contest plea. I understand the court's policy on that.
Okay, you obviously understand better, and I typically don't allow that, but if the state is unopposed, knowing what my position is, then I'll accept.
A guilty plea under these circumstances could have some collateral effects that the state's not necessarily intending.
All right, so did you enter your plea of no contest freely and voluntarily?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Galmore?
Yes, ma'am.
Do you fully understand?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. I see here the agreement for a no contest plea, that there would be only supervised visits allowed with the child victim in the case, and also that the parties agree, if the circumstances allow and if I approve it, an expunction under section or Article 55A or section 55A.101A2 in the expunction statute. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Stiles is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back for sentencing later. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see you back at
Thank you,
sentencing.
Judge.
Thanks, Judge.
Okay, let's see. Mr. Jeffries on Stephen Gomez.
Yes.
And for the record, Ms. Tucker's here. So Mr. Gomez tested negative. There's just, and I don't know what's going on. Obviously, lots of people are on drug patches and not testing positive as often as Mr. Gomez is. I appreciate the hair follicle test, but the only thing I can think, Ms. Tucker, is, so is he still in JCDI?
Yes, ma'am.
Okay. Can we do weekly UAs?
He's actually on UAs.
He is on random UAs?
Yes.
Okay. So I guess what I would say at this point is let's continue that. And if there's any other issue, let me know. He's tested negative in court. I know a couple times at least. Obviously, there's something going on that we need to figure out with the drug patch, because people don't just randomly test positive for meth on the drug patches. So continue doing what you're supposed to be doing on JCDI. And Ms. Tucker, if anything else happens, the only thing I know is just to let me know and send something over, and we'll have to figure it out at that point.
Yes, ma'am.
If there's something, and I don't know what all could cause a positive drug screen, if there's anything else that's going on in Mr. Gomez's life, but y'all might need to look into that. I'm sorry.
I was just.
So, if there's something else that could potentially cause that positive, that needs to stop, whatever it is, even if it's not something illegal. I don't know what it could be, but it's time to kind of dig further into lifestyle and what's going on. Every single thing that is being put into your body needs to be kind of adjusted and discussed with your probation officer so that we know what's going on and why you're testing positive. Okay.
We've done all that.
Well, I don't need any more. I just work with Miss Tucker because there's something going on. Okay. So I'm not putting you in custody. We're not filing a motion to revoke your probation, but something is going on to cause this. One drug patch that tests positive, I would say, okay, there could be an issue with the patch, but consistent issues, something is happening. Something's in your body that's making it test positive, whether it's illegal meth or some other supplement or food. I don't know. I'm just saying it's time to figure it out. Okay.
Yes, I love it.
All right. You can go. Thank you.
Thank you.
Thank you, Mr. Jeffries. Okay. Mr. Rojas and Mr. Coleman, are y'all ready on Janisha Leonard?
Yes, we're ready, Judge.
She's given a second chance, but it comes with a warning. One mistake, and she could spend the rest of her life in prison.